Good afternoon, ladies and gentlemen. I'm Peter Goddard, Director of the Institute of Advanced Study. It's my pleasure to welcome you here this afternoon for the third of our annual series of lectures on public policy, which has been endowed at the Institute. After the lecture, there'll be a reception to which you're all invited in Ford Hall, where we can continue the discussion. There will also be an opportunity for questions and answers at the end of the lecture. Today our speaker is David Cole, who is Professor of Law at Georgetown University Law Center. Professor Cole took his bachelor's degree in 1980 and his doctorate in law in 1984 from Yale University. He's a volunteer attorney with the Center for Constitutional Rights, legal affairs correspondent of The Nation, and has been a regular contributor to the New York Review of Books. Professor Cole's book with Jules Lobel, Less Safe, Less Free, Why America is Losing the War on Terror, won the Palmer Civil Liberties Prize for the best book on national security and civil liberties in 2007. His most recent book is The Torture Memos, Rationalizing the Unthinkable, which is about the tactics approved for use in the CIA's secret prisons and the arguments used to justify them. He's been involved in many of this country's most important recent cases involving civil liberties and national security. His work on human rights has been acknowledged by awards from many organizations, including the Society of American Law Teachers, the National Lawyers Guild, the American Civil Liberties Union of Southern California. Today his title is Torture and Accountability in the War on Terror, What Should Be Done? Professor Cole.
Thank you, Peter. So I'm going to talk about the process by which the United States, for the first time in its history, officially sanctioned torture. But before I talk about that, I thought it might be good to start with the evidence. And so I'm going to begin with a reading, and I'm going to ask Kim Shepley, who is a professor of comparative law, one of the leading professors of comparative law in the country. She teaches at the Woodrow Wilson School here, although she's visiting at Yale Law School for the year. And she's going to come up and join me in just for the opening as we read from two documents that are highly relevant to this subject. I'll be reading from the memos that, the initial memos written by the lawyers in the Office of Legal Counsel that authorized the CIA to engage in what the CIA called enhanced interrogation techniques. Kim will be reading from a first-hand account of Abu Zubaydah, who was the first person upon whom these tactics were employed. He's one of about 20 people who've been called the number 3 man in Al-Qaeda, and he was detained in a CIA secret prison, and it was his detention that caused the CIA to request the approval. So we'll do a short sort of back and forth reading, and then we'll turn to the topic at hand. You have asked for this office's views on whether certain proposed conduct would violate the prohibition against torture found in Section 2340A of Title 18 of the United States Code. You have asked for this advice in the course of conducting interrogations of Abu Zubaydah. In light of the information you believe Zubaydah has and the high level of threat you believe now exists, you wish to move the interrogations into what you have described as an increased pressure phase. This phase will likely last no more than several days, but could last up to 30 days.
About 2.5 or 3 months after I arrived in this place, the interrogation began again, but with more intensity than before. Then the real torturing started.
In this phase, you would like to employ 10 techniques that you believe will dislocate his expectations regarding the treatment he believes he will receive and encourage him to disclose the crucial information mentioned above. These 10 techniques are: 1, attention grasp. 2, walling. 3, facial hold. 4, facial slap, insult slap. 5, cramped confinement. 6, wall standing. 7, stress positions. 8, sleep deprivation. 9, insects placed in a confinement box. And 10, the waterboard. You have informed us that you expect these techniques to be used in some sort of escalating fashion, culminating with the waterboard, though not necessarily ending with this technique.
2 black boxes were brought into the room outside my cell. One was tall, slightly higher than me, and narrow, measuring perhaps 1 meter by 3/4 of a meter and 2 meters in height. The other was shorter, perhaps only 1 meter in height. I was taken out of my cell, and one of the interrogators wrapped a towel around my neck. Then they used it to swing me around and bash me repeatedly against the hard walls of the room. I was also repeatedly slapped in the face. As I was still shackled, the pushing and pulling around meant that the shackles pulled painfully on my ankles.
Cramped confinement involves the placement of the individual in a confined space, the dimensions of which restrict the individual's movement. The confined space is usually dark. The duration of confinement varies based on the size of the container. For the larger confined space, the individual can stand up or sit down. The smaller space is large enough for the subject to sit down. Confinement in the larger space can last up to 18 hours. For the smaller space, confinement lasts for no more than 2 hours.
I was then put into the tall box for what I think was about 1.5 to 2 hours. The box was totally black on the inside as well as the outside. It had a bucket inside to use as a toilet and had water to drink provided in a bottle. They put a cloth of cover over the outside of the box to cut out the light and restrict my air supply. It was difficult to breathe.
For walling, a flexible false wall will be constructed. The individual is placed with his heels touching the wall. The interrogator pulls the individual forward and then quickly and firmly pushes the individual into the wall. It is the individual's shoulder blades that hit the wall. During this motion, the head and neck are supported with a rolled hood or towel that provides a C-collar effect to help prevent whiplash. To further reduce the probability of injury, the individual is allowed to rebound from the flexible wall. You have orally informed us that the false wall is in part constructed to create a loud sound when the individual hits it, which will further shock or surprise the individual. In part, the idea is to create a sound that will make the impact seem far worse than it is, and that will be far worse than any injury that might result from the action.
When I was let out of the box, I saw that one of the walls of the room had been covered with plywood sheeting. From now on, it was against this wall that I was then smashed with the towel around my neck. I think that the plywood was there to provide some absorption of the impact of my body. The interrogators realized that smashing me against the hard wall would probably quickly result in physical injury. During these torture sessions, many guards were present, plus 2 interrogators who did the actual beating, still asking questions, which the main interrogator left to return when the beating was over. After the beating, I was then placed in the small box. They placed a cloth or cover over the box to cut out all light and restrict my air supply. As it was not high enough even to sit upright, I had to crouch down. It was very difficult because of my wounds. The wound on my leg began to open and started to bleed. I don't know how long I remained in the small box. I think I may have slept or maybe fainted.
Finally, you would like to use a technique called the waterboard. In this procedure, the individual is bound securely to an inclined bench, which is approximately 4 feet by 7 feet. The individual's feet are generally elevated. A cloth is placed over the forehead and eyes. Water is then applied to the cloth in a controlled manner. As this is done, the cloth is lowered until it covers the nose and mouth. Once the cloth is saturated and completely covers the mouth and the nose, airflow is slightly restricted for 20 to 40 seconds due to the presence of the cloth. This causes an increase in carbon dioxide level in the individual's blood. This increase in the carbon dioxide level stimulates increased effort to breathe. This effort plus the cloth produces the perception of suffocation and incipient panic, i.e. the perception of drowning. During those 20 to 40 seconds, water is continuously applied from a height of 12 to 24 inches. After this period, the cloth is lifted, and the individual is allowed to breathe unimpeded for 3 or 4 full breaths. The sensation of drowning is immediately relieved by that removal of the cloth. The procedure may then be repeated. The water is usually applied from a canteen cup or small watering can with a spout. You have orally informed us that this procedure triggers an automatic physiological sensation of drowning that the individual cannot control, even though he may be aware that he is in fact not drowning. You have also orally informed us that it is likely that this procedure would not last more than 20 minutes in any one application.
I was then dragged from the small box, unable to walk properly, and put on what looked like a hospital bed and strapped down very tightly with belts. A black cloth was then placed over my face, and the interrogators used a mineral water bottle to pour water on the cloth so that I could not breathe. After a few minutes, the cloth was removed and the bed was rotated into an upright position. The pressure of the straps on my wounds was very painful. I vomited. The bed was then again lowered to a horizontal position, and the same torture carried out again, with the black cloth over my face and water poured on from a bottle. On this occasion, my head was in a more downwards position, and the water was poured on for a longer time. I struggled against the straps, trying to breathe, but it was hopeless. I thought I was going to die. I lost control of my urine. Since then, I still lose control of my urine when under stress.
In order for pain or suffering to rise to the level of torture, the statute requires that it be severe. Although the confinement boxes, both small and large, are physically uncomfortable because their size restricts movement, they are not so small as to require the individual to contort his body to sit, small box, or stand, large box. You have also orally informed us that despite his wound, Zubaida remains quite flexible, which would substantially reduce any pain associated with being placed in the box. The facial slap and walling contain precautions to ensure that no pain, even approaching severe pain, results. The slap is delivered with fingers slightly spread, which you have explained to us is designed to be less painful than a closed-hand slap. The slap is also delivered to the fleshy part of the face, further reducing any risk of physical damage or serious pain. Likewise, walling involves quickly pulling the individual forward and then thrusting him against a flexible false wall. You have informed us that the sound of hitting the wall will actually be far worse than any possible injury to the individual. The use of the rolled towel around the neck also reduces the risk of injury. While it may hurt to be pushed against the wall, any pain experienced is not of the intensity associated with serious physical injury.
I was then placed again in the tall box. When I was inside the box, loud music was played again, and somebody kept banging repeatedly on the box from the outside. I tried to sit down on the floor, but because of the small space, the bucket with urine tipped over and spilt over me. I remained in the box for several hours, maybe overnight. I was then taken out, and again a towel was wrapped around my neck, and I was smashed into the wall with a plywood covering and repeatedly slapped in the face by the same 2 interrogators as before. I was then made to sit on the floor with a black hood over my head until the next session of torture began.
As we understand it, when the waterboard is used, the subject's body responds as if the subject were drowning, even though the subject may be well aware that he is in fact not drowning. You have informed us that this procedure does not inflict actual physical harm. Thus, although the subject may experience the fear or panic associated with the feeling of drowning, the waterboard does not inflict physical pain. As we explained in the Section 2340A memorandum, pain and suffering, as used in Section 2340, is best understood as a single concept, not distinct concepts of pain as distinguished from suffering. The waterboard, which inflicts no pain or actual harm whatsoever, does not, in our view, inflict severe pain or suffering. Even if one were to parse the statute more finely, to attempt to treat suffering as a distinct concept, the waterboard could not be said to inflict severe suffering. The waterboard is simply a controlled acute episode, lacking the connotation of a protracted period of time generally given to suffering.
This went on for approximately 1 week. During this time, the whole procedure was repeated 5 times. On each occasion, apart from one, I was suffocated once or twice, and was put in the vertical position on the bed in between. On one occasion, the suffocation was repeated 3 times. I vomited each time I was put in the vertical position between the suffocation. During that week, I was not given any solid food. I was only given Ensure to drink. My head and beard were shaved every day. I collapsed and lost consciousness on several occasions. Eventually, the torture was stopped by the intervention of the doctor. I was told during this period that I was one of the first to receive these interrogation techniques, so no rules applied. It felt like they were experimenting and trying out techniques to be used later on other people.
Thank you, Kim. So this is a story about how law and lawyers failed, in my view. The lawyers were approached by the CIA in connection with the detention of Mr. Abu Zubaydah and asked whether these techniques, which include stripping suspects naked, keeping them awake for 11 days straight, slamming them into walls, forcing them into painful stress positions, slapping them in the face and abdomen repeatedly, and ultimately waterboarding them, were legal under U.S. law and under international law and under our Constitution. And the lawyers concluded that they were legal, that every one of these measures was perfectly lawful, meaning it was not torture, it was not cruel, it was not inhumane, it was not degrading, it did not violate the Geneva Convention's requirement that we treat all detainees in a military conflict humanely. Law at its best, I think, constrains power, protects the vulnerable, and expresses our highest ideals. Law at its worst, I think, is a cloak to power, exploits the vulnerable, and is treated as infinitely manipulable so as to justify whatever the client seeks to do. This is a situation in which law was at its worst, not its best. And one of the things that I think is very important in thinking about the implications of the way the lawyers acted when the CIA asked them whether these techniques, never before approved, clearly illegal if the FBI employed them on even the worst terrorist captured in the United States, clearly illegal if used by the military. When the lawyers who were approached to give an opinion on this come from a particular office in the Justice Department. It's called the Office of Legal Counsel. And their performance, I think, is especially troubling given the role and institutional function that this office plays. It is often said that the Office of Legal Counsel is the constitutional conscience of the executive branch. It is designed, as one of its heads said, to keep the executive, who is in charge of enforcing the law, within the law itself. Whenever the executive branch, any agency in the executive branch, has a question about the legality of some measure that it seeks to employ, it goes to the Office of Legal Counsel. And that office's job is to look at the conduct and assess it against the law and require the agency to conform its conduct to the law. The office is a highly prized job, one of the most elite jobs in the Justice Department, in the executive branch for that matter, often filled with former Supreme Court clerks, some of the smartest young people coming out of law school. Its alumni include Chief Justice William Rehnquist, Justice Antonin Scalia, Benno Schmidt, former president of Yale, Harold Koh, until recently the dean of the Yale Law School and now the legal advisor to the State Department, Cass Sunstein from Harvard, probably the preeminent constitutional law scholar in the country, Ted Olson and Walter Dellinger, both former Solicitors General to the United States, and many, many judges, federal judges as well, including Jay Bybee, who was the author of the memo, or the signator of the memo that I read with Kim, and is now a confirmed federal judge on the U.S. Court of Appeals for the Ninth Circuit. So these are supposed to be the best of the best, and their job again is to hold the executive branch accountable, and that job is done for the most part in confidence. They're providing confidential information, advice to the executive branch. So there's no adversarial presentation of views. There's no open hearing. It's all done in a closed office. When it comes to covert activities like this, the enhanced interrogation tactics, the Office of Legal Counsel is often the only entity that will pass on the legality of the conduct in question, because it will never come to light. It will never get to a court. It will never get to Congress, because neither of them will ever find out about it. We found out about this one, but of course they couldn't have known that when it began. And in this particular instance, these lawyers were the only line of defense for the individuals against whom these tactics would be employed, because these individuals were themselves disappeared. They had been picked up by the United States in various parts of the world and then spirited off to these secret CIA prisons known as black sites. And we didn't acknowledge that we held them. And they were not entitled to any access to the outside world, not to their families, not to their consular officers, not to lawyers, not even to the International Committee for the Red Cross. So the Office of Legal Counsel was truly the last line of defense, the first and last line of defense. And when you're in that position as a lawyer, there's a different set of obligations on you than when, for example, you are a criminal defense lawyer and someone has come to you after the fact, after having committed some act, and your job is to argue in an open proceeding as best you can to minimize the negative consequences for your client. But that's predicated on the notion that there will be a prosecutor arguing the opposite side, and there will be a judge and a jury which will render some objective judgment. And in that case, lawyers are sometimes referred to as hired guns, and they make whatever argument they can. But when you're a lawyer giving advice before the conduct has occurred, and particularly when you're a lawyer like these Office of Legal Counsel lawyers giving advice where you may be the only line of defense for the law, you have a different obligation. You have an obligation to be an honest broker, to call it like it is, to say no when the law suggests that the answer should be no. Had these lawyers said no, I don't think that Vice President Cheney would necessarily have taken no for an answer. I'm not sure he ever takes no for an answer, but I think that had they said no and insisted on no, that would have been the end of it. I don't think the White House would have authorized conduct which their own Office of Legal Counsel had officially told them was illegal. But once they said yes, then they essentially had granted the cabinet-level officials who authorized the program and the CIA interrogators who applied the program essentially a get-out-of-jail-free card. Because once the Office of Legal Counsel has said that the conduct is lawful, then it's very, very hard to hold a person accountable for engaging in what the the office has said is in fact lawful activity. Now, I don't think that, I think there are some hard questions in applying the Torture Convention to some of this conduct. There are some hard questions, less hard, in applying the cruel, inhuman, and degrading treatment prohibition to this conduct. That's a much lower threshold of conduct, still illegal, but a lower threshold. But there are difficult line-drawing questions, to be sure. But what is most striking to me about the period of time over which the office authorized these tactics is that they never said no. They always said yes to whatever the CIA proposed. You would expect with difficult line-drawing questions that they might come out with a nuanced opinion that says some measures may be okay under certain kinds of conditions, other measures clearly not. Waterboarding, the most obvious example, but sleep deprivation for 11 days, also a very, very strong case for a prohibition under both torture and the cruel, inhuman, and degrading treatment conduct. But instead of requiring the CIA to conform its conduct to the law, what the lawyers did was contorted the law to conform the law to what the CIA wanted to do. And it wasn't only the initial 2002 memos from which I read at the opening. This went on for a 5-year period. And it went on while the law in public seemed to underscore more and more clearly that these kinds of tactics cannot be employed. But what we had was that was the law in public, and we had a separate law, the law in practice, which was in secret, in which the Office of Legal Counsel continued to write secret memos saying that this was permissible. So, for example, this first memo that I read from was secret. It was leaked in 2004 to the Washington Post. As soon as it was leaked, it was roundly condemned and criticized, and they felt that they had no choice but to rescind it. And they did, publicly. And they publicly replaced it with another memo in 2004, which started, "Torture is the most abhorrent conduct known to mankind, and the United States is absolutely against it under all circumstances," and was written in a much more reasonable way and sounded a much more restrictive. But what we now know is that at the same time they were writing a secret memo which said to the CIA, you know, yeah, that was a public relations ploy, but still everything that you have asked to do is legal under the new interpretation that we have advanced. Similarly, with cruel, inhuman, and degrading treatment, their initial position on cruel, inhuman, and degrading treatment, which, as I said, is a much lower standard than torture. And so, you know, even if you can argue about whether sleep deprivation for 11 days and stripping a suspect naked are torture, you can't really argue that they're not cruel, inhuman, or degrading. And so what they did initially in secret was to say, well, that prohibition, which is in the Torture Convention, an international treaty, just doesn't apply to foreigners held by the CIA outside of our borders. Just doesn't apply. In other words, they took an international human rights treaty predicated on human dignity and said it only applies to Americans outside of our border, not to foreigners. They did that in secret, and therefore they didn't have to get into the question about whether any of these tactics were cruel, inhuman, or degrading until that became public. And as soon as that became public, Congress erupted, and led by John McCain, almost unanimously enacted a law to make it absolutely clear that the prohibition on cruel, inhuman, and degrading treatment in this international treaty applies to anybody held by the United States, anywhere, no matter what passport they have. And so what did the Office of Legal Counsel do? They then wrote another secret memo telling the CIA that all of these tactics actually, now that we think about it, are not cruel, inhuman, or degrading either. And then in 2006, the Supreme Court, they also had to deal with the Geneva Conventions, which require that you treat all detainees in a military conflict humanely. That's been interpreted to require very, very fair kinds of treatment. You really can't engage in abuse of prisoners of war or other detainees under common Article 3 of the Geneva Convention. So the government's position with respect to that, like cruel, inhuman, and degrading, was it just doesn't apply. Until the Supreme Court in 2006 said, yes, it does, in a case called Hamdan. So then what did the Office of Legal Counsel do? It wrote another secret memo saying, well, actually, now that we look at it, Geneva Convention, even if it applies, none of these tactics would be inhumane, and therefore none of them violate the Geneva Conventions. Meaning, in essence, that our military members in the next war have no grounds to object if they're subjected to the same kinds of tactics that Abu Zubaydah was. He was waterboarded, by the way, 83 times over the course of his treatment. Khalid Sheikh Mohammed was waterboarded 183 times. So even as the law seemed in public to be more restrictive, they continued to interpret it in secret to permit what the law prohibited. They did so even after they learned through a CIA Inspector General report on the practice, even after they learned through that report that the CIA had repeatedly abused these powers. There was no way of determining whether any of the valuable information we got from CIA detainees, and we did get valuable information from the detainees, but the CIA Inspector General said there was no way of determining whether that information, that valuable information, was obtained by lawful tactics, lawful non-coercive tactics, because those were also employed, or these coercive tactics. So no way of knowing that they were actually working. But they still continued to approve it. That Inspector General report also found that there was no evidence that any ticking time bomb, any imminent terrorist threat had been thwarted through evidence obtained by virtue of this program. But they continued to approve it. And even as we got years and years away from the attacks of 9/11, and many people say, well, you can't look back, hindsight is 20/20, but think about how we felt on 9/11, and we can't really judge them fairly from today. But these memos continued to be written up through 2007, 6 years after the attacks of 9/11. As Dahlia Lithwick of Slate has said, the view of the lawyers in the Office of Legal Counsel seemed to be that anything was okay as long as it came with a side of memo. So how did they do it? The first memo was leaked in 2004, and so there's been 5 years of analysis. So all these other memos only just came out in April 2009 when the Obama administration agreed to release them in response to a lawsuit filed by the ACLU. But the initial memo, which came out in 2004, written in August 2002, employed this standard, which I'm sure many of you are familiar with. They said, well, what does it mean that torture is only the infliction of severe physical pain and prolonged mental harm? What do those terms mean? And they interpreted severe physical pain to be pain rising to the level of organ failure or death. So anything short of that is not torture. And prolonged, what does prolonged mental harm mean? And they said, well, it's prolonged mental harm means harm lasting months or years. So anything short of that is permissible. And they also said that the statute requires specific intent to inflict that severe harm and that prolonged, severe pain and that prolonged harm. And so even if, it happens to be the case that waterboarding inflicts severe pain or prolonged harm, if the agent didn't intend to inflict severe pain and prolonged harm, but just less than severe pain, then there's no problem. They also said that the president, as commander-in-chief, could order torture, full-blown torture, despite a criminal statute prohibiting it, an international treaty prohibiting it that we've signed and ratified, because as commander-in-chief, he cannot be checked by either Congress or the courts in how he chooses to engage the enemy. And in making that argument, they didn't even cite the most important case on presidential power during wartime, Youngstown versus the Youngstown-Sheeton Tube versus Sawyer, which was a case about President Truman trying to seize the steel mills during the Korean War. And he argued, I need to do this for the war effort, to engage the enemy because there's about to be a national strike and I need to avert it. And the Supreme Court said you can't, because Congress has implicitly said that you can. It didn't make it a crime to seize steel mills. It just didn't give him the authority to seize steel mills. And the Supreme Court said, well, if Congress hasn't given you the authority, you can't do it. Here, Congress not only didn't give the president authority to torture, but it made torture by federal officials a felony. And the memo said, without citing Youngstown-Sheeton Tube, that the president could simply override that. It also said that that a CIA interrogator who did torture, even without presidential approval, could invoke the self-defense defense. Now, usually the Justice Department, which prosecutes crime, takes a very dim view of the self-defense defense, a very narrow view of the self-defense defense. But here, they adopted a view that is more expansive than any that I've ever seen a criminal defense lawyer dare to propose in a court. They said self-defense usually allows you to respond to an imminent physical threat to yourself by taking proportionate action against the individual who is attacking you. And now, obviously, when Abu Zubaydah was stripped naked and strapped to a board, he didn't pose any imminent threat to anybody in that room, but they said, well, you can treat the threat as the threat to the nation. That's the self-defense. It's the threat to the nation. And it doesn't really have to be imminent because it could be so big that imminence is no longer really a relevant concern. The subsequent memos abandoned some of those arguments, but they essentially advanced two arguments. One was that these tactics can't be unlawful because we use many of these tactics in training our own military to withstand abuse from other countries. It's called survival, evasion, resistance, and escape training. And many, many military get it. They sign up for it. It's voluntary. And they are then subjected to many of these tactics up to and including waterboarding. And they said, well, we've talked to the psychologists who worked with this program and came up with this program, and they say, one, it's really effective, and two, it doesn't really cause any pain because none of these military people have complained. But of course, that's in the setting in which you volunteer to be subjected to these tactics, in which your friends are subjecting them to you in what you know is a drama, in which you are given a code word that you are allowed to say at any point which will automatically stop the proceedings. Very different from the context in which it was being applied to people who were being detained not by their friends but by the enemy, where they knew that there were no limits that applied, where they had no recourse to any kind of protection, much less a word that could stop all of the tactics from being applied. It's like saying, because consensual sex doesn't cause any serious harm, neither does rape. And yet that was time and time again the argument that the memos went back to. We do it to our own people, therefore it can't be illegal to do it to others. Second argument that they went back to time and time again, and which is very troubling, I think, is that, well, to the extent that maybe in some circumstances this might go over the line and cause serious pain, etc., we'll have doctors and psychologists there, and they'll stop it. Because as soon as they see that it gets to the level of severe pain, they'll certainly order it to stop. Never addressing how a doctor is supposed to be able on the spot to distinguish between pain and severe pain. And never addressing the fact that the doctors and psychologists that were going to be on the spot were the seer doctors. In other words, the doctors who had spent years being inured to these tactics because they only observed them in essentially a fake dramatic play acting version. Having them in the room is hardly likely to protect anyone except maybe the lawyers and the interrogators from legal culpability after the fact. And so, in some sense, what is most troubling about this is that these memos and this system developed into essentially a officially sanctioned, professionalized application of cruelty. You know, torture, you think of torture sometimes as some out-of-control guard or police officer or security officer going overboard and inflicting pain on an individual. But this was not that. This was vetted by the highest lawyers in our government, approved by the cabinet-level officials from Dick Cheney on down, and overseen in its minutiae by doctors and psychologists who were implicated in the program. And so it says something very disturbing, I think, about the professions and the ability of the professions to withstand the kind of pressure that we saw after 9/11. So what should be done about this? What should be done about this? One set of responses, I think, are institutional reforms. We should think about whether there are ways in which things went wrong in the Office of Legal Counsel and try to make sure that that doesn't happen again. You could require the inclusion of interested parties, which is what they usually do in the Office of Legal Counsel, but they're not required to do. And in this instance, reportedly, they kept out of the discussion people who they knew would raise objections, people from the military and people from the State Department. The other thing you might do is put somebody in that office who speaks up for the people, speaks up for human rights. The DHS has such a person. He's the officer for civil rights or something like that. And one of the things he does is he sits in on policy discussions, and his job, his institutional role, is to raise the concerns not of the government, but of the people who the government policies are being applied to. There is no such voice in the Office of Legal Counsel, and precisely because it's a closed office, in many instances a covert a decision-making process, it's very important, I think, to have alternative voices, and that might provide some check going forward. But I think what's most critical is that there be some form of official accountability. That we say to the world and to ourselves that this was not just a bad idea. It wasn't just a mistaken policy, but it was illegal. It was illegal. And that's critical because that is essential, I think, to creating a bulwark against it happening again. It doesn't mean it won't happen again, but it makes it less likely that it will happen again if we have officially, formally, in some measure, condemned it as illegal. It also makes it less likely that other countries around the world will feel free to employ these tactics. Right now, and there are many countries who will use any argument they can use these arguments, and they can say, well, look, the United States did it, and yes, President Obama stopped it, but no one was held accountable, and therefore President Obama didn't agree with it, but that doesn't mean a country that does agree with it can't do it. And so we will see copycat actions throughout the world, unless there is some form of accountability. So what does accountability mean? Does it mean a criminal trial? I'm not holding my breath for the day in which we have a case filed on the docket, the United States versus Dick Cheney, John Ashcroft, George Tenet, Alberto Gonzalez, Condoleezza Rice, John Yoo, Jay Bybee, Donald Rumsfeld, David Addington, and all of the others who authorized this program of brutality. But I also think that it's not necessarily the only way that a country goes through an accountability enterprise. that we are actually legally obligated by the Convention Against Torture to investigate and refer for prosecution, not necessarily to prosecute, but investigate and refer for prosecution any credible evidence that someone within our country has engaged in torture. And we are right now violating that obligation. And there is right now in Spain a judge named Baltasar Garzón who indicted Pinochet for, among other things, torture, who is conducting his own investigation for possible prosecution under a principle of universal jurisdiction of the lawyers in particular who authorized these tactics. But it's our obligation, not Spain's obligation, to investigate the crimes. We have not done so. But accountability can take other forms. It could take the form of barred disciplinary actions, and reportedly there's an ethics office report within the Justice Department that is going to come out at some point, but whose results have already been leaked to the press, which recommends that these lawyers be referred to their state bar disciplinary councils for discipline. But experts in ethics say that there'll be tough cases, actually, to get discipline on because professions don't like to discipline their members, and so they put very, very high bars to achieving actual discipline. And moreover, it seems, in some ways, it would seem odd to have a fully sanctioned scheme of torture authorized at the highest levels of our government, and all that you come out of it is that a couple of lawyers get bar disciplinary provisions. But it would be a forum, at least, for some form of accountability. You might also have impeachment of Jay Bybee, the judge who signed these memos, and depending on what the Office of Professional Responsibility says about how he played his role, that's a possibility. You might have congressional resolution. You might have civil damages actions. There are many forms of accountability. Now, I'll just give one example. The Japanese internment of World War II, which at the time was authorized by the executive branch, not objected to by Congress, affirmed by the Supreme Court, in which 120,000 people were detained simply because they were of Japanese origin. But people fought for accountability on that case for many, many years. And ultimately they were vindicated. And in 1988, 40-plus years later, President Reagan signed a law that officially apologized for what was done and paid reparations to the surviving victims. That's a form of accountability. At this stage, I think it's too early to say, actually, precisely what form of accountability is appropriate, because we don't actually have all the facts. And so, to me, what would be most sensible is to set up an independent commission, a commission that's above partisan reproach, a commission made up of people like those on the 9/11 Commission, who will be tasked and authorized to get out the full story and to report on the full story and to make judgments about whether the laws were broken. And then once those judgments are made, then we can make determinations about what the appropriate next step might be. But we can't, as President Obama has suggested, simply look forward and not backwards. Because if we do so, then the law in this country will be that when we have a president who doesn't believe in torture, like President Obama, we won't torture. But when we have a president, or more relevantly, a vice president who does believe in torture, we will. Torture becomes a policy option. That's where the state of the law at this point remains. And the whole point of the Convention Against Torture, this international treaty that we played a central role in getting the world to sign on to, that President Reagan signed and the Senate ratified under his tenure. The whole point was to take torture off of the table as a policy option under any circumstance. We've put it back on through these tactics, and absent some accountability, it will remain an option on the table. Thank you very much. I'd be happy to take a few questions before we go to the reception. Yes.
Thanks very much. About our duty to investigate and defer to prosecution. Of course, from your last remarks, it's premature to talk about what would happen if this commission were established, we got the full story, and initial judgments were made, and then we could determine the next step. But could I just say I would be very disappointed if we decided we only
When I say, just to be clear, when I say refer for prosecution, all I mean to say is that the language of the convention is written somewhat open-endedly, I think in recognition of the fact that in some countries, civil law countries, in theory anyway, like Spain, a judge makes the determination whether to prosecute, and there's no discretion about it. If the facts suggest a crime was committed, you prosecute, period. In common law countries, including the United States, that's not the way prosecutions go. Prosecution is an executive decision. It's always discretionary. Prosecutors don't have to prosecute, even where there's, unrebutted factual evidence of crime. And every day they decline to prosecute cases for a variety of reasons. So that's the only sense in which I meant. I didn't mean necessarily refer it outside for prosecution. I think the law requires us to consider prosecution. But I also think that, were I a defense lawyer, just to take the other side, were I a defense lawyer, I could mount a decent defense for the cabinet level officials and for the lawyers in an actual criminal case. I mean, for the cabinet level officials, one of the things that's interesting about the cabinet level officials, with the exception of John Ashcroft and Alberto Gonzalez, none of them were lawyers. Very unusual. But Dick Cheney, George Tenet, Donald Rumsfeld, Condi Rice, not lawyers. And so their position would be, look, we didn't choose to torture. We didn't intend to torture. We felt it was our obligation to go up to the line because of the threat we were facing. And so we went to the lawyers and we said, where is the line? They told us where the line was, and then we authorized only up to that line. And they gave us a 65-page memo with lots of citations, and none of us are lawyers, and it seemed reasonable to us. So that's their defense. And the lawyer's defense is, well, we were asked by the cabinet level officials where the line is to be drawn. And these are not self-defining terms, severe, prolonged, etc. And we felt it was our job to read the law given the circumstances. It wasn't our role to tell the cabinet level officials that they couldn't do something that they felt was important to our national security unless we felt that there was no argument that could be made, no reasonable argument that could be made to justify, to authorize these tactics. And so we applied that very deferential standard, and in those circumstances, that's what we did. We believed that this was conduct short of torture. And unless you can prove that they didn't believe that, not an easy thing to prove, it may be that there, I mean, as I say, there's not, all the evidence is not out yet. This ethics office report, I think, will be very interesting because it goes into some of the early drafts, some of the faxes and communications, and those might, in fact, shed a very different light on this. But just on the face of it, I think a criminal defense lawyer, could make a defense. And so a prosecutor might decide, well, I've investigated. I think there's a crime here, but I'm not sure I could prove it beyond a reasonable doubt, and I'm not going to go forward with it. That's within their discretion. I don't think they could decide within their discretion properly, I'm not going to go forward with it because it's Dick Cheney and it would be too divisive and he's too powerful. But I think that there are other grounds upon which one might decide not to prosecute. But I also just think it's, from a pragmatic point of view, it's highly unrealistic that it will happen. I wouldn't, I wouldn't object to it if it happened, far be it. But I think it's highly unrealistic, and so I think it's incumbent upon those who want accountability to think about other measures which might serve in the broader scheme a similar end. I mean, I do think nobody went to jail for the Japanese internment, and yet I do think that the lesson of that whole process is that was wrong, even though the Supreme Court said it was right. And that means it's, I think, quite unlikely that we would have that kind of detention again in the wake of an attack. I think that the sort of lesson of that process is one that we have learned. And in much the same way that in England, they have learned, I think, the lesson of the initial forays against the IRA, where they used these same types of tactics. And they were determined formally by the European Court of Human Rights in its first decision to be illegal. And that, when you go to the UK and you talked about tactics in fighting terrorism, torture is off the, everybody agrees it's not permitted, and these kinds of coercive tactics as well, not permitted. There's nobody arguing for it. It's not like here where you have polls saying 50% of the American people think it's a good idea, or 60% if they just watched 24 think it's a good idea. So I do think a country can learn through these kinds of processes. Yes? Well, there aren't that many. I mean, universal jurisdiction is a principle that is recognized in international law, which says with respect to some crimes like torture, they're so egregious that countries can prosecute them even if they don't have some direct connection to the crime. But not that many countries actually have formally created that authority in their courts. Spain has. And Spain has sort of done the most with it, the Pinochet case being sort of the principal one. But even in Spain, it's controversial. And so these cases, one of the things that's happened with these cases is that the Spanish legislature has cut back severely on the universal jurisdiction principle to limit it to cases in which there is more of a direct nexus to the country. But as you rightly point out, there are many countries that do have a direct nexus because they're, yeah. Right. Yeah. Yeah. Yeah, well, right. I think it likely has to do with geopolitical relations and a desire not to piss off the United States and particularly Obama, to not put this headache in Obama's lap. But that doesn't necessarily answer it, because in a civil law jurisdiction you can sort of get the thing going by going to a judge, as they did in Spain, and then that judge he's not a diplomat. He doesn't take into account, foreign policy considerations. He just looks at the facts and decides whether to go forward, at least in theory. In Germany, there was an effort to get the Germans to prosecute Rumsfeld for some of this, and the German authorities, the German courts said it was premature. So there was an effort to do it on behalf of some of the German victims, but it hasn't gone anywhere. The only place place where it's gone anywhere is in Spain, and it's still at a very preliminary stage in Spain. Yes.
Can you explain Obama's unwillingness to look back and bring all of this accountability?
I think there's two things going on for Obama. One is what he says, well, what his people say, right, which is that, well, I mean, actually, it was interesting. What he said was not that there should be, he did say we should look forward, not back. But in his May national security speech at the National Archive, which is really a great speech, actually, he didn't say there should be no accountability. He said there are mechanisms ongoing in the courts and the Congress. And so I don't think we need to create a commission. That's basically what he said. And there, you know, and there is an investigation in the Senate Intelligence Committee. There are some cases. Of course, what he didn't say is that the Obama administration is continuing to advance in all the cases that are seeking accountability the same defense that the Bush administration advanced, which was that all this is secret and therefore the courts can't adjudicate whether it was illegal or not. But what his aides say is we don't want to divert attention. This will be hugely divisive. It would suck up all the attention, and you know we want to do some things like health care reform and the like, and we just wouldn't be able to do it if we created this huge maelstrom. I think that that's part of it. I think that's sincere, and I think it's they're probably right in terms of the cost. I don't know how you measure those political concerns against a legal obligation we have to do something. I do think, though, that accountability, as the Korematsu and the Japanese internment case illustrates, accountability doesn't have to necessarily occur immediately. It can be, it can occur later. But I think there's a more fundamental thing going on, and that is that I think the Democrats are still very, very afraid of being portrayed as caring more about terrorists' rights than American security. And that's, going after this aggressively, that's even the limited amount that Eric Holder has suggested going after, that is going after the CIA interrogators who went beyond the authorized brutality and, threatened to kill one detainee's children if another terrorist attack occurred, and threatened to sexually abuse another detainee's wife and mother if he didn't tell them what they wanted to know, and stuck a gun up to somebody's head and cocked the trigger for another individual, and took a power drill up against a person who was hooded and naked and revved it right by the person. Those people are being investigated, and even with respect to those people being investigated, Dick Cheney's response is, see, they care more about the terrorists than they care about your rights. And I think the Democrats are afraid of that, of being played that way, and that makes them less than eager to be pushing for a commission. Yeah. 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 In fact, some people thought. Well, it depends on what you mean by stand up. It would legally stand up. That is, the president has untrammeled discretion to pardon anybody for anything at any time, and including these sort of advanced pardons. So, I mean, you can't pardon people for things that they might do in the future, but he can pardon people who have not yet been convicted. Weinberger was pardoned in that way for I can't remember what crime he committed, but yeah. So that is it's a possibility. Legally, it's certainly a possibility. Politically, it's complicated. I mean, I've been asked in other forums, well, what about? I mean, what about pardons in exchange for a full-fledged investigation and accounting by a commission? That in other words, that sort of it's an exchange. We're not just pardoning, but we're actually going to, the pardon allows us to really, to look back in a way. And in some sense, that the Ford pardon can be said to have done that, and it sort of freed up a kind of full-blown inquiry of into the Watergate stuff. You know, I don't know. I think that's I think an argument could be made for that. I think my own sense is that before we know the facts, it's hard to sort of stomach that. And so I'd rather get the facts out. And it may well be that once the facts are out, one concludes that prosecution is not the right response, but some other response is the right response. But to sort of preclude that at the outset before we know the full story seems premature. But it is a way to get to accountability that might be politically viable and might. Yeah, in the very back, yes.
Last line of defense with respect to these sorts of these sorts of practices, and technically that's certainly true. But in between sort of that first and last line, there are a whole lot of other lines that sort of failed miserably, you know, over the course of many years. Most prominently, the CIA's own internal set of lawyers, and probably more so, the congressional committees. And it seems to me that it's that second group that, for obvious reasons, we don't really talk about as much, but it also seems to me that the most plausible sort of institutional location where something might have been prevented was in Congress. And certainly they didn't have all the information available to them. But it also seems to me the case that they certainly didn't do as much as they could have, even given the limited information that they had. I was just wondering if you could speak about that for a little.
Well, yeah, you know, no, it's certainly true that there are other lawyers who were involved in this, the CIA lawyers, the Army's lawyers who, you know, subsequent to this, authorized not tactics this extreme, but but nonetheless tactics that violate the Geneva Conventions to be employed at Guantanamo, and so there is culpability beyond these lawyers, to be sure. But with respect to the congressional committees, you know, I think the question there is sort of what could you do institutionally about it. I don't, you know, I don't think you can really hold the members of Congress to account. Here's what happened. They were a small number of members of Congress in each house, you know, maybe 5, 6, something like that. The leadership were briefed by Dick Cheney or others about the program, on the condition that the briefing was top secret and classified, and that you cannot share this information with anybody, not with your staff, not with your spouses, not with your fellow members of Congress. That was the condition upon which the briefing took place, in both this context and the NSA wiretapping context. And so, you know, what do you do as a Congress member? And we don't really know how that briefing was actually presented, right? We don't know how explicit it was, et cetera. But suppose, you know, it was very explicit and you're very concerned. What do? You can't, under the terms of this, you're not allowed to share the information with your fellow members of Congress who then might be able to do something about it. So, you know, one question is whether we ought to, that ought to be an appropriate condition on these kinds of briefings. The concern, of course, is if it's a legal covert operation, you don't necessarily want it to be broadcast to the world, and Congress is not the most secure institution in terms of confidential information, but you sort of, it becomes, that process under the way it's constructed now, I don't think is oversight at all. I think it's just a kind of a way for the executive after the fact to say, oh yeah, we told Congress, but we told Congress in a way that they were basically institutionally incapable of doing anything about it. So that's my view about the role of Congress. Yeah. Yeah.
It would seem to me that there could be some different standard or some threat of disclosure that automatically, for example, files become public.
Yeah, 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 yeah.
But something that would act as a disciplinary
Yeah.
mechanism.
Yeah. Well, one thing people say is, look, I mean, if you're in Washington, you know that there are going to be leaks. You know that, very little is actually going to remain secret for very long. And so there is already that threat of sort of the judgment of the public. No, it's not institutionalized. We rely on people breaking the law in order to achieve that. But yeah, I mean, I think we do have certain, but we do have certain sort of presumptions for disclosure after very, very long periods. But it's so long that the people who are involved will likely not be alive at the time that the reckoning, if there is any, occurs. And I'm not sure that that has much. Yeah.
Years ago, there was a big problem with corruption in California in bond council selection of local municipalities. And at that time, the governor simply set up a commission which had subpoena powers, and the level of corruption went down. They never prosecuted a single case, but the threat was there.
Yeah, yeah, yeah. No, that's a good suggestion. I'm going to take one more question, and then we should probably go to the woman here. Yeah, yeah.
Your phrase, the deferential standard, is very helpful for describing, very captivating, and one of the things that we see
Yeah.
used by the office. So we're trying to think through the institutional forms of approach to see the degree to which they would work against the deferential standard a little bit. But I wonder whether one has to ask a question about the culture of the legal profession thing in order to deal with
Yeah.
the development of a standard for the law.
Yeah, absolutely. And I mean, one of well, I think a couple of things. One is that I don't think that deferential standard is right. But I think that you could make that argument before a jury, and it might, on a beyond a reasonable doubt criminal case, you might be able to prevail. You don't have to necessarily prove that it's right. You just have to prove that that beyond a reasonable doubt you weren't culpable because you adopted this view, which others have adopted. I do think that there is a kind of understanding in the bar that there is a difference between your role as a advisor before conduct has occurred, in which, and particularly a confidential advisor, where you're supposed to be an honest broker, you're supposed to provide contrary precedent, you're supposed to warn somebody about the consequences of illegal conduct, and your role after the fact, and that's built into the system. But there's a way in which, one friend of mine who's written about this says, part of the problem is the way we teach law, and we teach law as not all of us, but many of us teach law as if any side can be defended on any issue. And it's all a game, and it's about the most clever people coming up with the most clever arguments, and that's what law is about. Law is, that is what law is about if you're, I suppose, if you're a tax lawyer, and you're searching for loopholes, and you're looking for the most clever loopholes. And maybe that's what it's about if you're a criminal defense lawyer and you've got somebody who's done something bad, but your job is to limit the harm that's done to him, and there's an adversarial system, et cetera. But I think we've sort of taught people that you can defend anything, and this, in some ways, this is the fruit of that. I mean, I don't know how entirely fair that is, but I think there's a grain of truth to that criticism of the way in which law has come to be taught. And on that optimistic note, why don't we go to the reception?